Hi, Stuart. This is Sue McCrossin from Boomtown, and I have with me Stuart Carpey. He is one of my clients at Boomtown Internet Group, and he's a personal injury lawyer in the Philadelphia area, also with an office in Conshohocken. And
Hi, Stu.
Hi, Stuart. And I've asked Stuart to come on because a lot of our clients and a lot of people around the web have posed questions about what's legal and what's not legal as far as ownership of copyrighted images or just images in general, and also what they're allowed to do as far as creating reviews for their sites, for their local listings, to enhance their local listings. So I'd like to break it into two topics, and we'll talk about the reviews first. Stuart, as a digital agency, how much are we allowed to help our clients do in their efforts to improve local search rankings and local reviews? And I'd like you to refer to a case that I read about in New York last year where there was about $350,000 worth of fines because a New York Attorney General posed as a bad yogurt or a yogurt maker and asked people to create reviews, and they did so.
Right.
Internet marketing companies. So, can you help my clients understand?
Yeah.
All right.
Yeah, sure. We those of us in the legal end of this kind of stuff, we read when we're aware of what the Attorney General's office in New York did, and there were substantial fines to the violators of those, the businesses that had fake reviews. And there's also another component to this, because I'm not sure what the Federal Trade Commission did to those small businesses, but there were FTC violations as well. I think that might still be under investigation. And also, that was just one Attorney General. So all the other states could impose the same types of fines depending on what their rules are. And obviously, the rules are going to be similar from state to state. So the bottom line is reviews have to be, true and accurate. Otherwise, the business runs the risk that some Attorney General or some regulator from the FTC is going to be coming after them in a similar fashion that the Attorney General did in New York. So no fake reviews, nobody posing as a reviewer. They've got to be, the real McCoy.
And what if a business has already, created unknowingly, 5 years ago, created a review that's questionable? Maybe they asked a family member to write a review, or maybe they paid, $5 to everybody who came into their store to write them a review, and somehow or other that sort of kind of walks the line. What should they do with those reviews?
Okay, well, first of all, as you said earlier, I am a personal injury lawyer, so I'm not giving you this information from an intellectual property lawyer's point of view, but as a marketer in the digital space myself, for reaching my prospective clients, this is the kind of stuff you and I talk about, and I think about all the time. As long as the review's accurate, even if, I dare say, if it's somebody as long as it's a true and accurate review, I don't have a problem with that. But if it's something that anybody is concerned about, you got to obviously take the review down. My understanding is that Google has their own rules that have become more stringent, so you're going to become penalized if the review is in that gray area anyhow, based on what Google sees. So bottom line is, if it's a review that concerns you, first rule is just make sure it's taken down. Then you've complied. How Google penalizes you after that is up to their own, systems.
Great.
In my opinion.
I value your opinion, Stuart.
Thanks.
Now, I'd like to switch topics a little bit, because I said that we're going to have two different questions. And my second question is about using images. Say, for instance, you have the perfect blog post, and you find this absolutely, complimentary image that just illustrates exactly what you're trying to say. And you'd like to use that image, but you didn't create it. What are the steps that you need to take? And I'd also like you to refer to the fact that recently, I think in several different states, there have been people who have been fined for, just taking an image and posting it in their blog post, and the fines have been extensive, like in some cases over $8,000.
Right, I've seen those too. I mean, there are lawyers that specialize in copyright and intellectual property law that make it their, the types of cases that they handle are going after copyright infringers, and whatever the statutes say about the fines, I mean, it's pretty much strict liability, meaning if it's a violation, the person or the company that infringed on someone else's copyright, they got to pay. And the law in this country, these are federal laws, these aren't state laws. They favor the artist. They favor the creator of that piece of content. They don't favor at all the entity that utilized that content for their own purposes. So as we know, there are for instance, the sites, is it Flickr that we use and other companies use for photographic material and other graphic stuff. Those owners of that copyrighted material have acquiesced and have paid or have been paid so that their piece of content, their photograph or whatever, is now in the public domain, and it can be utilized. But the steps I would think that I would go through, if I found the perfect image, I'd contact the owner of that piece of work and ask if I could use the image, and I'm sure it has to be in writing, and there's probably a price for that, like any other piece of work. This country favors the author, favors the writer, and the debate really isn't, okay, well, I thought it was okay, and it was a perfect image. You got to get permission from the creator of that piece of content.
How about as a follow-up question? I've noticed that while it's not an image, it's actually a video. It kind of looks like an image when you're looking at a blog post, and I was thinking that you're allowed to embed videos, and perhaps that can kind of walk the line. What do you suggest about embedding videos into blog posts that you didn't create?
It's an interesting question, and I don't know that we can find the answer right now. I certainly don't have the complete answer, but what I believe applies is when for instance, when you take a video from YouTube, you have to agree, you check off certain okays, from Google and YouTube, that you agree to comply with their user manual or whatever. In the user manual, I'm sure it says that once you put this video up on YouTube, it's now in the public domain. So you, as the creator, have given up your right to claim it can't. It's a copyright infringement from this point forward. That's the distinction. So if I find a perfect image in a newspaper, whether it's a photograph or some other graphic piece that I want to put on my great blog that I just think ties the whole thing together, whether or not that's got a little seal on the image or not, it's copyrighted. Once the image is out in the public domain, it's copyrighted unless the person gives up that right to the copyright. And I believe the answer is, but I'm not 100% sure, that once I put this video up on YouTube, for instance, I've given up my rights to claim it's copyrighted. I don't know who owns the copyright. Maybe YouTube does at that point. But that's why we're permitted to embed YouTube videos into whatever it is we're doing, for instance. I hope that helps.
Yeah, that's been great. And if ever, as a follow-up, I may call you back and ask you questions if I get responses to this blog post. But thank you very much, Stuart, and I'll check back in again with you. And thanks again.
Until next time.
You too. Bye.